I'd like to welcome you to Risk Management in Psychological Practice. This is actually will be a 3-hour webinar. It's part of a much longer presentation that I did, which, as you can see from the slides, is called Malpractice in Psychology. But it is basically risk management principles, along with some understanding of exactly what the concept of malpractice is all about. Okay, the first question, how do I keep from getting sued? Well, let me just tell you a harsh reality. The likelihood is very, very great that at one point or another in your career, you will get sued. Okay, it's just the reality of the litigious era in which we live. But that does not mean you are going to get successfully sued. And what we need to do is to minimize the risk of successful lawsuits. So there has been a dramatic increase in numbers of malpractice actions filed. Interestingly enough, the rate of successful malpractice suits has stayed pretty much the same over the years. Perhaps a very slight increase, but nothing that is dramatic. So it basically means that folks are practicing good psychology, careful, well-documented, using appropriate techniques, and with the exception of some of the really extreme kinds of situations, such as having sexual relationships with a client, most people practice quite safely. And it's important to demonstrate how that careful practice will minimize the risk of successful lawsuits. So to put it briefly, the chances are you will get sued. The chances are you will get sued successfully, very minimal. Now, one of the reasons for this, we have to understand the legal basis for liability. The legal basis for liability is not just that something goes wrong. That can happen to anybody, and it can be unforeseeable. The legal basis for liability is that something goes wrong because you, the practitioner, deviated from an accepted standard of care, and that it was the deviation from the standard of care that resulted in the harm or injury to the plaintiff or to the plaintiff's family. Okay, so it's not just that something bad happened. Patient committed suicide, patient acted out violently, something of that sort. That has to be linked in what is called proximately. It has to be demonstrated that there is a cause and effect relationship between something that the therapist did or did not do and the resultant outcome. Otherwise, it's just regarded as an unfortunate circumstance. Now, once again, that won't stop a hungry attorney from trying to convince a judge that, in fact, it was your fault. But if you understand these principles well, then the likelihood, it is highly unlikely that any of this will result in professional liability.